There were a couple other good things at the beginning of that writing is communication chapter. Okay, for example, the goal is generally to write in plain English and avoid what we call legalese. Okay, legalese is simply terminology that in the law we all understand, but the average layperson does not. Okay, avoid excess words. I like that too. And unnecessarily Latin phrases and legal words. Okay, so we want to try to avoid what we call legalese, particularly when we're writing to clients. Okay, we can use a little more for writing to other lawyers or to the court, but even then, I think, in my own personal opinion, simpler is. Another great suggestion in this section is to have somebody else read over what you've read. What you've written. Okay, whether it's another legal secretary or your attorney or whoever. When you give it to somebody else, they have a different perspective on things. They don't know what you're writing about. And the less they know about it, in my opinion, in most cases, not all cases, obviously, the better. Okay, because particularly when you're writing to a client, they're not going to understand their body and knowledge of law is not going to be as sophisticated as yours or your attorney. Okay, so in that sense, get somebody else who really, I mean, sometimes I'll give things to my wife to read over. She's not a lawyer. She doesn't know anything. Does this make sense to you? Do you understand it? Okay. If you do, good. Then maybe I've got a good chance that a judge might actually understand it. Okay. I'm being a little facetious there, but say later. Another thing we do with legal writing is what we call leaving a paper trail, or more appropriately called CYA. Or if you don't understand what that means, it means cover your ass. Okay. A lot of times we send stuff out of the office just to make sure that things don't come back and bite us later. For example, pretty much anything that goes on in a case, we send a letter to the client, so they know what's going on. So they can't come back later and say, I didn't know this. If I'd known this, I would have settled the case, or I would have done X instead of Y. Okay. So a lot of the times what we're doing with our writing is documenting what we've done. So later on, somebody can't come back and say, oh, God, you didn't do this, you didn't do this. We can come back and say, yes. Let's talk about the elimination of mechanical errors, which is a little bit further in this chapter. Okay. One of the reasons we want to try to eliminate mechanical or semantic or grammatical, whatever type of errors you want to do, is because one of the biggest problems with bad writing or poor writing is when you read it, you're concentrating on the bad writing itself. Oh my God. How could you write like this? The second that happens, the reader stops thinking about the message. They're focusing on the form as opposed to the content. Okay. You in your own mind might think you've written something really brilliant, but if it's worded poorly, then you might not get your message across. The main two of these typographical errors being, spelling errors and grammatical errors, things like that. Okay. Nowadays we have spell check, but don't assume spell check is going to catch everything. It doesn't. Okay. You have to go back and do your own proofreading. Spell check is not a substitute for proofreading. If you're really concerned about your mechanical errors, I would invite you to review and read Appendix D in the book. At least in my book, it's Appendix D. It might be something different, called Mechanical Errors. Okay, that's the name of the appendix chapter. It happens to be D in my book. It might be something different in yours, but that's a really good little supplement to the material if you're not feeling confident. Another type of a mechanical error that this section talks about is, for example, quoting from a head note. Okay, a head note is written by a publisher. A lot of you that haven't taken legal research won't know what I'm talking about, but basically they're summaries of points of law. You can never quote from a head note. You have to quote from the exact text of the body of the court's opinion itself and give reference to the exact page number. Okay, so never quote from a case summary or a syllabus. Another error that they're talking about here is plagiarism. Okay, now I'll talk a little bit about plagiarism later, but in terms of the law, one of the things I'm going to teach you is Learn to copy from other people. Okay, it's not plagiarism to take somebody else's motion, rearrange it, and go ahead and submit it. It is in this class, but in the real world it is not. Okay, I copy stuff from attorneys all the time. If somebody submits a good motion and it comes across my desk, I keep a file of stuff. Man, that's a really good a motion to change venue or whatever it is. I can use this if it comes up to me. So one of the things that I really encourage you to do, and this is imperative if you really want to become a good legal research and writer, is start keeping a file of good work, because you can use that work and go back to it later and reference it. Okay, so start if you see a letter coming in from another attorney, like a demand letter asking for settlement or something like that, save it, change it, rearrange it, make it suit your needs. Okay, that's not plagiarism. Okay, let's talk about the different types of legal writing. Okay. The first one that is mentioned in your book is the use of legal writing designed to inform. Okay, we're going to tell somebody something, usually in an objective way, okay, as opposed to a persuasive way that we'll look at in a minute. Okay, for example, a transmittal letter to a client. Okay, a letter to a third party. Okay, meaning somebody who's not involved in the case. And an opinion letter that might go to a client on how we think their case might come down. Or an office memo where we do our own internal legal research to help us prepare for a case or a motion. Okay, those are all documents that are designed to inform. Okay, the tone is neutral or objective. Okay, we're not trying to put a spin on anything. We're just trying to tell it the way it is. And right now I'm just doing a summary. Believe me, later on in the class we'll discuss the nuances and variations of these things in detail, and hopefully I'll be able to try to teach you how to write some of them myself. Okay. The next type of legal documents are those that are designed to persuade. Okay, we're trying to convince somebody to take some action. Okay, an example would be like a demand letter, where I send a packet to I used to do personal injury on the plaintiff side a lot, and most cases settle. So when all the facts are out there and a lot of the discovery's been done, or maybe even before a case starts when I'm dealing with an insurance company, I'll write a letter to them doing things like detailing my client's injury, the liability or fault of their client, and persuade them or convince them to give me a lot of money. The more the better, right? Okay, that's an example of persuasive writing. Okay, another obvious example is when we submit things to the court. Any type of motion or a trial brief or a brief to an appellate court after trial, if we think the judge has screwed up. Those are all examples of court documents that we submit to persuade the judge, grant my motion, deny the other side. If I'm on the other side, deny the motion. Okay, change the case. Let me go back and retry it if we're before an appellate court. Okay, give my client money. Okay, these are all examples of letters or documents where we're trying to persuade somebody to do something. Obviously, hopefully in the best interest of our clients. There's another type of legal documents out there that are designed to record information. Okay, for example, a will or a deed that transfers, property from one person to another. Things like that. Those are documents in which we're trying to record information. Okay, we will touch on those. I will cover them, but I'm not going to spend a lot of time on. For example, I'm not going to have you draft a will, certainly, and I'm not going to have you draft a deed. There are other classes that can do that. I'm not going to have you file documents with the Secretary of State setting up a new corporation. Those are all examples of documents that are to record information. Okay, they are certainly important and they definitely need to be done right, but we won't be spending a lot of time on those types of documents. This is the end of the lecture for Chapter 9. Give me some feedback and let me know if you liked it, if there are things that were confusing or you don't understand or you want me to expand upon. I can either do that through email or We could FaceTime or whatever, Skype. Just let me know and we can set it up. I hope this was helpful. You guys have a great day.